Good evening to all. Today we are going to see about the case laws judgments in 2022. And first one is the Supreme Court reiterates that acquittal in a criminal trial has no bearing on disciplinary proceedings. Actually, in this case law, actually a driver rashed driving. Because of rash driving, he has been charged in the police station. The FIR filed in the section IPC section 279 and the 304A, as you all know about the 304A. So he has been got under that, and the criminal trial was going in the court. And subsequent to that, the Karnataka Maharashtra State Transport Corporation has also initiated the inquiry, domestic inquiry. For that, the employee has asked the employee filed the writ petition before the court to squash the this one, actually domestic inquiry, because the criminal trial is going on. But the court said, here you can see, the apex court held that the order of industrial court is bad in law. The dismissal in the present case cannot be said disproportionate to this one. The driver was acquitted of the charges under section 279 and the 304A of IPC, and the prosecution failed. Actually, in this case, the police failed to prove the charges leveled against him under section 279 and the 304A. So the employee has asked to decline this this one. As per the cardinal principles law, on acquittal in a criminal trial has no bearing on or relevance on the disciplinary proceedings as standard of proof. Both the cases are different, and the proceeding to operate in the different fields and the different objectives. So in this case, very clearly said, the criminal trial will go separately, and the domestic inquiry will go separately. Both things will operate on a separate manner. So the writ petition has been dismissed, and the Supreme Court has go ahead with the Maharashtra State Corporation to go ahead with the domestic inquiry. That is the first case law from the Supreme Court. In a next case law is, in disciplinary proceedings, a delinquent employee has the legal right to appoint a defense assistant. Normally, in the domestic inquiry, we allowed the employee to bring his co-worker to help him, not for conducting the inquiry or pleading in the inquiry like that, but he can get the assistant because he may be unaware of the procedures, and he may be on the desperations because of charges like that. He has to allow the defense. Actually, in a case law, in the Madhya Pradesh High Court, in the case of Deenabandhu Sagat versus State of Madhya Pradesh, this petition is filed in the that is knocking the Article 226 of the Constitution of India. The decision, somebody is audio. Please mute your audio. Please mute your audio. The decision bench comprising Sin Nahu and Purushadev Kumar Kajav held that the delinquent employees and disciplinary proceedings has a right under Rule Section 18(4) in the Madhya Pradesh civil case to engage the defense assistant for his disciplinary authority. That is allowed, and the MP civil court has asked the inquiry officer to ask the controlling officer to allow the defense assistance as a right under principles of natural justice. We all aware of that. We have to conduct a domestic inquiry as per the principles of natural justice. So the Madhya Pradesh High Court has allowed the that is directed the inquiry officer to advise the controlling officer of the respective state civil services to allow the employee to bring the defense assistance for the delinquent employee. That is the next case. And another case, the Supreme Court ruled that employee is not exempt from the liability just because of he has retired or superannuated. So if an employee, when the definition come from the ID Act, the employee definition very clearly stated that even though the discharged or dismissed the employee or retired or superannuated, he cannot escape from the inquiry. So he has to undergo if the inquiry has going on, so he has to appear. That is another case came from these things, because I couldn't able to capture what is the case law in that. And the next case law, lowering punishment by tribunal. Actually, in this case law, the observation was made by the division bench of Justice Ajit Rastogi and Abhyay S. Oka in the case of United Bank of India versus Bachchan Prasad Lal, while dealing with the appeal filed by the United India against 2010 order of Patna High Court upholding the decision of Industrial Tribunal to reduce the punishment handed out to the respondent employee. In this case, the respondent was working from 1973. He has been suspended on 7/8/95 for irregularities, and he has been dismissed for dismissal followed by an inquiry. Dismissal happened on 6/12/2000 actually, and he has filed the writ petition before the Patna High Court for his dismissal, and holding that the tribunal has empowered to say in section 11A actually. But the Patna High Court has quashed the dismissal order, but the company has made an appeal to the Industrial Tribunal under section 11A, and the SC rejected and condemned the tribunal for lowering the penalty. In this case, the tribunal has lowering the punishment by that is not giving the increment and other thing. So they made the judgment like that, but the Supreme Court has condemned that one in this case law. That is in the case law of United Bank of India versus Bachchan Prasad Lal. That is the another case. Because the Supreme Court condemned the authority not to lower the punishment like reducing the increment like that. So that is, they said that this is shockingly disproportionate to the to this case actually. Another thing is deputation to overseas. This is another peculiar case. Sarita Singh working in Sri Infosoft Limited. She was working at there. She has been sent to the overseas, and for improving their performance, and the skill training has been given in abroad. And she returned back, and he resigned from the job. And she resigned in the year 2013. That is 12/12/2013. And whatever the amount spent for their training in abroad, the company has asked to refund the money by way of notice. And court also observed that in this case, Supreme Court has observed that the employee has refused to pay the amount because the company only intentionally for to improve their performance of the company, they put like that their standard. That is from the Sarita Singh stand, but the court said that, very clearly said that if the employee and the company and whoever received the service of the particular company has made an agreement stating that the deputer consent to depute and the borrower consent to borrow, consent by the employee to be debited, and the written agreement between the deputing employer and the borrowing employer and the employee as to the terms of deputation. So, if the agreement has made between the employee and which company is deputing her and which company is borrowing from here India to some other country, if they made an agreement, in the agreement, if the terms and conditions as stipulated, they have to abide by that. That is the judgment given in this case. In this case, actually, Labor Court cannot adjudicate the dispute related to employer-employee relation matter under section 33C. In this case, the employee filed a petition for difference in wages, and the court said that Actually, in this case, the Labour Court adhered the matter before going to the Deputy Commissioner of Labour under Section 33C2 of ID Act. Very clearly stated that if the wage or something bonus or something like that, it has to go to the commissioner. Then he has to advise the company, or if the company is not ready to pay the money, he can issue the recovery notice to the government. Thereby, he can get the relief from the case and all. But in this case, the employee has filed the petition before the Labour Court, not to knock the door of Deputy Commissioner of Labour. So his case has been returned actually. Labour Court awarded 28/11/17 to pay the arrears, but the Supreme Court asked this should be referred under Section 10 of ID Act. So he should not directly comes to the Labour Court. That is very clearly set in the section of 33C2 of ID Act. Because in this case, there is no employee relation also. The worker is working as a dealer in that company, but he stated that he is an employee. So SC reviewed everything and SC asked to knock the appropriate forum in this case. In the case of remittance of EPF dues in installment may be permitted subject to sufficient cause. Actually, in this case, the company, the Forest Industries Limited, is not paid the employees' provident fund dues to the provident fund, and they issued the notice under Section 7A. And in that notice, they locked the bank account because to get the relief from the bank account opening, they issued the notice. Then they got the relief from the appellate tribunal. After that, they stated that EPF court, they paid the money to get the open of the bank account. But even though the EPF authority has not allowed to open the account, so they approached the court, and the court said that already they made some deposited amount and they are ready to pay the amount. But the EPF is not ready to allowed to open the account of the particular company. And considering they are under the very sick and they could not operate the business, so they can be allowed to open the account and settle the amount to the employees. And the company is also ready to deposit the dues. That is said in the High Court of Kerala in the case of Forest Industries Limited versus Assistant Provident Fund Commissioner. This is another case. Actually, in this case, the worker is working in sugarcane cutting machine. While cutting the sugarcane machine, he died because of snake bite, and he filed the petition. The deceased victim family has filed the petition before the commissioner. And the commissioner directed the employer to pay the amount, but the employer has paid the amount from the date of the award, not from the date of the accident. So in this case, the Supreme Court clearly said that the compensation to be paid from the date of the accident, not on the date of the judgment or award. That is very clearly said in the case of Shobha versus Sherman, Vitarra Sinde Sakari Karkara Limited. That is upheld by the Supreme Court. And another one case, oral termination without an order, Lumsum compensation has been allowed by the Gujarat High Court. A contract appointment has held and the employee has been terminated, and he filed the petition, and the petition has been heard, but the company was under sick, so they could not operate here afterwards. So considering the above things, company also incurred more of loss and all. So they directed the company to pay the lump sum amount, because there is no employer-employee relationship. the employee has been appointed as a temporary and their contract has not been renewed. So the High Court, Gujarat High Court has directed to pay the lump sum amount of 2.5 lakhs in lieu of 20% back wages with the reinstatement. Because in this case, the Labour Court directed to pay the 20% back wages with the reinstatement, but Gujarat High Court has reviewed, writ petition has been filed in the Gujarat High Court. So Gujarat High Court reviewed everything and they considered that the company is not performing well and incurring so much of loss. So at this juncture, they invoked the section of 25F and 25G under the ID Act. So they asked to pay the lump sum amount instead of reinstating the employee with the back wages of 20% in this case. That is in the case of, they also referred in the case of Maharashtra State Board versus Kalavadi Pandurang, and by referring the judgment, they given this judgment. And the settlement between the workman and the management not binding under section 18 of Industrial Dispute Act, if not sent to the prescribed authorities. That judgment has been delivered in the Rajasthan High Court. A company has made a settlement between the union and they have not sent the memorandum of settlement to the conciliation officer, the labor authority. And some of the people doesn't like the settlement and they filed the petition before the labor court, and the labor court asked to file the 18-1, registered the settlement with the labor authority after signing the settlement. If not, that is not the valid settlement. That is given in the judgment by the Rajasthan High Court. And in this case, Labour Court has no jurisdiction to adjudicate the workman claim under section 33C2 ID Act in under undetermined claim. That is in the Karnataka High Court. In the case of management of KSRP versus Sri K. Sivaram, Karnataka High Court has said that workmen who claim compensation due to injuries suffered during the course of employment, his claim under employee compensation would lie before the employee compensation, not before the Labour Court. In this case, the employee has filed the petition before the Karnataka High Court instead of filing the petition before the ESI authority, and then only he can approach the appropriate relief from the appropriate forum. Before that, he has filed the petition in the Karnataka High Court. So the court directed that this petition before the section 33C of ID Act, but this should be lies with the employee compensation, that is ESI court, not with the ID. That is delivered in this judgment. And the employee who agrees to contractual engagement are not permitted to later pursue the benefit under section 25F of the Industrial Dispute Act in Gujarat High Court. In the case of Rajmilaben or Thakur versus Index PC Industrial Extension, Gujarat High Court ruled that the petitioner cannot considered retrench under section 25 of ID Act upon the expiry of the contractual agreed fixed term, and hence it was not entitled to retrenchment payment of compensation. If the employee is ready to work under the temporary or trainee, something like that, after that they cannot make a stand that they can get the permanency of employment under invoking the section 25(2) if they had been retrenched. Actually, that is the judgment has been delivered in the Gujarat High Court. And another case law, temporary employee cannot seek permanent employment. Gujarat High Court reaffirmed finding the Labour Court, in which the court has relied upon the Supreme Court decision, State of Karnataka versus others, which the Supreme Court ruled in the backdoor entries were not permitted without due procedures, and the temporary employees could not receive the same benefits as permanent employees of the establishment. The High Court refused to dismiss the impugned order, stating that petitioner has signed the consent letter for 1 year appointment and the Labour Court has issued the well-reasoned order, hence the petition was dismissed. Continuity of service with the back wages can be directed cases where the retrenchment was bona fide. In the This case was held in the Supreme Court because the employee has already agreed to work as a temporary employee, and many of the cases the temporary employees are knocking the doors under the section 2A, but this cannot be encouraged, and this should be stopped as directed by the Supreme Court in the case of Rajamilan or Thakur versus Index PC. That is in the case. And another case, suppression of material fact. A person was working as under constable in CRPF and checked when on appointment, tells there is no criminal track record. So he has been appointed on August 2011. After later it was found that the case was registered against applicant under section 147, 323, 324, 504 and 506 of IPC. All are grievous criminal track record. So the respondent, after conclusion of the inquiry and terminate the service of the applicant in the exercise of power conferred under their central rules. Aggrieved by the judgment, Delhi High Court which upheld the termination, and the appeal was thereby preferred to the Supreme Court in this case. That is, a person was appointed as a constable under CRPF, but he has not explicitly said that he has got into the criminal track record under section 147, 323 and 324 and other sections. So after exploring the things and all, the authority has conducted the inquiry and he has been terminated, and he has approached the Delhi High Court, and the subsequent Delhi High Court said that if the person has suppressed the material fact, so his termination is valid, and he preferred the appeal in the Supreme Court in this case. And his appeal contention is prosecution against him was very trivial in nature, and it did not involve any moral turpitude. He said that all this criminal FIR, whatever said in the FIR, that and all trivial nature, but the respondent said that guilty of suppression of the material fact, which by itself was sufficient to terminate his service. In this case, the Supreme Court has laid down some under direction to the authority, even on truthful and correct declaration of the concluded criminal case by the employee reserves the right not to appoint the employee considering his antecedents. Acquittal in criminal case is no guarantee for appointment to the post. Very clearly, Supreme Court said that when a person has been got into a criminal case, he cannot get the right of getting an appointment when the criminal case, he has suppressed the material fact. Next thing is ground such career prospect and the age of the candidate leading to the condemnation of the offender's conduct, and other such generalizations should be avoided and not enter into the judicial verdict. Some of the people making plea that after a year or so of appointment, he can make a plea because of he could not get the employment after 45 or after 40 years of age, and his educational qualification as a mercy that cannot taken into consideration while the employee has suppressed the material fact of the case. That is the second point reiterated by the Supreme Court in this case. And the court should inquire as whether the authority concerned acted malified and with any elements of bias. Here, court also asked to inquire the authority has got the malified and any bias intention against this employee. That has also to be seen when the person to be screwed under the suppression of material fact. And the procedure of the inquiry adopted by the authority concerned must be fair and reasonable. The inquiry should be under the principles of natural justice. These are the some of the points to be taken into consideration when a person is terminated under the suppression of material fact. Very clearly said in the Supreme Court judgment. And the next, an appointment made out of the compulsion is a concession, not a right. In this case, that is in the fact versus fact is the public sector undertaking, and others versus Anushree. Employee was died while he is under employment, and after 14 years of the death, the deceased family has approached the court for compassionate appointment. Court setting aside the judgment of the division bench of Kerala High Court, and they quoted from the Kerala High Court judgment, ruled that since it had been 14 years to go death of the deceased employee, the respondent shall not entitled to appointing on compassionate ground, stating that, and in this case, very clearly, Supreme Court said that when we are appointing an employee on compassionate ground, we should see that there is no breadwinner in their family. So that has to be seen apart from any other thing. That is very clearly stated in the Trivangur fertilizer chemicals case. In this case, this is, and it's a very good judgment from the Supreme Court, I would say. And some of the High Court cases here. Petitioner worked between 1979 to 2011, and he made into some of the allegations, misappropriation and disproportionate case filed by the CBI. That is, CBI filed the case against this fellow. That is in the case of Subbarao versus Inquiry Officer, Cotton Corporation of India. That is the public sector undertaking. And referring the case of case Sridhar versus Andhra Pradesh State Travangur case, the court dismissed the writ and said that both the proceedings go in parallel. Actually, in this case also, the criminal proceedings, the FIR has filed before the police station against an employee for misappropriation and disproportionate assets by the family members of the Subbarao. So they filed the case in the police station, as well as the disciplinary inquiry has also initiated, and this Subbarao has filed the case for asking the squash the petition, but the High Court has dismissed the writ petition in the Andhra Pradesh High Court, because both that is domestic inquiry and the police inquiry will go parallelly. There won't be any problem between these two, go in parallel actually. And in this case, one employee was working as a that is Kaushal Kishore Singh was working in one company that is in the Delhi, Sita Kauni World Travel India Limited, as a travel guide. Actually, he was appointed by some other third party, and there is no employer-employee relationship between them. So he has given the information, and some occasions he has been terminated, and he because of his termination, he filed the petition before the labor forum, and that went to labor court, and the labor court erred in appreciating the evidence on the record, which includes 8 mails, and duly supported by the certificate under section 65B of Evidence Act to show the correspondence between the workman and the management. The 4 forms of Form 16A. We all know about the Form 16A, that is income tax, and he showed that he said that this is the proof under section 65B of Evidence Act 1872 before the labor court, and he has made the priya before the labor court under section 2 years, and he stated that he is the workman, but after he made the petition, but the Sita Gauni World Travel India filed the writ petition before the before the High Court and said that he is not a workman because he is not come under the workman definition. That is, we all knows about the what is called workman, manual, unskilled, skilled, blah blah. So he is not the workman. And the respondent contention in this case is he is a workman and continuous, and the petitioner he is a regular employee. But the judgment said that it went to say that Form 16A clearly shows that TDS was deducted by the management respect of payments made to the petitioner under the head of payment made to the contractor and the subcontractor. So he was working and as a employee under the contractor. So he disqualified under Section 2S of Industrial Dispute Act. So in this case, the his plea has dismissed by the High Court, and the High Court has condemned the Labour Court judgment, not overseeing the whatever the documents shown as evidence. So they directed the Labour Court to see the evidences under Section 65B. And in this case, connection in employment, claim injury, New India Insurance Company versus Lakshmi. In this case, the court observed that whether the employee injury was caused by an accident arising out of the employment, or if the employee contracted any occupational disease. Actually, here the employee is not working in a company, but he left the company. After that, he said that he was under stomach pain, so he has gone to the hospital, and he died actually after the stomach pain and all. And the Lakshmi has deceased family has filed the petition before the commissioner. Commissioner also directed the claim actually, and the commissioner passed an award allowing the workman compensation under 3.3 lakhs, and this award Section 30 of Workman Compensation Act. And the New India Insurance Company made a writ petition before the court, and they asked whether the order of the commissioner is correct in view of the laid down disease suffered by the workman should be related to work done by him actually. In this case, the commissioner has not seen the medical certificate of the deceased, died person. So the commissioner has been directed to see the what is in the death certificate, what is in the mortuary report and other thing, because he has not died in the course of employment as well as in the arising out of employment. So this would be comes under the occupational disease. So that has to be taken into consideration by the Commissioner of Labor in this case. Whether the order of the commissioner is correct when the disease is suffered by the workman doesn't fall under the occupational disease as specific under the Schedule 3 of the Workman Compensation Act. These are all the issues taken into consideration by the court. So the court is directed to see those things. And another case, the jurisdictional fact of relationship between the accident and the employment had not been recorded. That is, false declaration or non-disclosure of material information on employment verification form can be result in termination from the service. This is another case held by the Supreme Court during 2022. In the case of Sadish Chandra Yadav versus Union of India, he suppressed the material fact. So his termination is upheld by the Supreme Court. This is the case. Because in this case, actually, he has been, he claimed that he has not passed the relevant examination held by the department, but he has said that he has got the right under the Constitution. This comes under the Constitution case, that is under Article 14. So the court said that these cases should be dealt. There are some formalities and the procedures, SOPs are there. So it has to go under whether the person has passed in the written examination or something like that. But this person has failed in the Hindi typing and the computer skill test. Out of 61 candidates, he also one among the candidates. He also failed in the examination. Like other candidates, He also failed in the examination, so his case cannot be considered. This is in the case of Satish Chandra Yadav versus Union of India. This is the judgment. They referred to the judgment of Rajendra Kumar Agarwal versus State of UP. The court held that petitioner has failed to demonstrate the notification under 21/6/2016, and he has actually he knocked the door by way of invoking the door of Article 14. So court rejected that plea. And jurisdictional fact relationship between the accident and the employment had not been recorded. In this case, Andhra Pradesh High Court has held that New India, this is the repetition of the case, whatever we see. That is in the case of New India Assurance Company versus Lakshmi. These are all the some of the cases I got collected from the 2022 case laws. That's what I want to tell.